Hudson with the Hudson Law Firm. We understand that many of our clients have never had an injury claim before, or perhaps this is the first accident they've ever been in. One of the most frequently asked questions that we have is, how does the injury claim process work? Well, we've put together what we call a personal injury roadmap. It's available on our website, personalinjury.com. And through that, you can follow this video, and we've tried to break it down into 9 stages. The first stage is medical treatment. Now, this is something that's going to take a while. This isn't a process that we can complete in 1 week or be done by next month. Because first of all, we don't know how long you're going to treat. And the reason why that's important is we can't rush to a settlement, get a settlement early, because we don't know if you're going to get better or if you might need some advanced procedures, an epidural steroid injection, or perhaps even a surgery down the road. Because if we've already settled your case, we know that the insurance company is not going to send us a settlement check until you've signed a release of all claims. And therefore, if you needed a surgery or something down the road, it would be too late to go back and get that included in your claim, and all the pain and suffering and mental anguish that goes with that. So stage 1 is we want to make sure you're getting the treatment you need. If you're already seeing a doctor through your health insurance, fine. If you need any help with finding doctors who will work under what we call an LOP, a letter of protection, they would treat you now without requiring payment, and they would just expect payment out of your eventual settlement. We do have a network of doctors that we can help you with. And that brings us to stage 2, which we call evidence collection. In that stage, we're going to be getting some of the initial medical records, perhaps emergency room or ambulance. We're also going to be getting a copy of the police report. We do have a list of items that we need from our clients. It might be pay stubs if we're going to make a lost wages claim for you, your insurance declaration page, and similar documents. In the meantime, you're continuing to treat. We're just wanting to get started on the evidence process. Moving on to stage 3, injury recovery. We stay in touch with you throughout the treatment process. We like it if you can, give us an email or whatever to let us know if things are changing, if you're being sent for an X-ray or an MRI, or perhaps, they're recommending that you go see a specialist. Obviously, if you need us to help you find one of those type of doctors under an LOP, we can do that as well. But we just ask that you follow doctor's orders. Try not to skip appointments. I know you can get busy, but skipping appointments or not following doctor's orders with home exercises or other instructions all gets noted in the record. Insurance companies are going to see those records, and they're going to try to stop paying at that point. Understanding that, if you're missing appointments, they read into it that you must not be hurting that bad if you're missing a doctor appointment. From there, we move on to stage 4, which is that we finalize the records. Your doctor has released you, you've called or emailed us to let us know, or your doctors let us know, and from there we need to go back and get all the final medical records and medical bills. We make sure that we have everything that we need to prepare a demand letter for you. Then we go to stage 5, which is sending the demand. We prepare a very detailed demand letter. Our average demand letter is probably about 8 pages or more. And in there, we're going to talk about all the details of the accident, your injuries, your pain levels, everything you did for treatment, all the limitations you have and probably still have, how it's affected your job and making a lost wages claim, and then, of course, all your pain and suffering and mental anguish that we're going to have in that demand letter as well. We like to go into detail about things like, how it's affected your life. I can tell the adjuster all day long about, your injuries and how many doctors you went to. But when I can also tell the adjuster that, you have a 3-year-old and you can't wrestle on the ground with them like you used to, that speaks volumes. And that's the level of detail that we're looking for in your demand letter. We always send the demand letter to you for review once it's completed, and we can obviously make any changes or supplements to it from there. We also attach all the records to your demand letter. So it's all the medical records, all the medical bills, all the photographs of the accident or your injuries, bruises, scratches, cuts. We also have a police report. Any other supporting documents are all going to be attached to that demand letter and sent to the adjuster. Once that's sent, we're moving on to stage 6 now, which is evaluation. So you will see in the demand letter that we give the adjuster 2 weeks to review all of the records, all of the information, sometimes a pretty thick packet of information that we've given them. They have to go through all that with a fine-tooth comb themselves. Even though we've already done it for them, they obviously do it themselves. And then they have to have time to go visit with their boss about getting authority for making an offer in your claim. We've already given them everything they need to document their file so they can justify to their boss why they're making such an offer for your claim. We like to give them 2 weeks because we found that they get upset with us if we don't give them at least 2 weeks. And from there, they do call us sometime and ask for an extension, might ask for another 2 weeks, but rest assured, we always try to limit them to something shorter than that because we don't want to keep putting on the process forever and ever. From there, we move on to stage 7. All right. Once they've reviewed everything and made an offer, that's when negotiations start. And it's not something that we can do in a day or two because when you call an adjuster, inevitably you got to leave a voicemail and then you got to wait for them to call you back. Does that take hours or does it take days? It depends on the insurance company. It depends on the adjuster assigned to your claim. So it's an important process. We're very good at negotiations. We're very good at what we do, but it just takes some time because we're dealing with an adjuster on the other end. So from there, after we've negotiated and we've beat them up or whatever we need to do to get them to go back to their boss and get more authority for your claim, we move on to stage 8. And that is the decision whether or not to settle your case or perhaps we'll make a recommendation of taking your case to trial. Now, that is not our objective. We always would prefer to settle if we can get the adjuster into a reasonable range of what would probably be likely if you were to go to trial. That's obviously the best solution. Most of our clients don't want to go to trial, they don't want to have to give a deposition, and they don't want to extend the process that much longer. Going to trial may take another year or 2 years before you ever reach the courtroom. So we do visit with you about it and we make our best recommendation, but we'll also let you know if we think they're not in that reasonable range of settlement, we can talk to you about the options of filing a lawsuit. And then we go to the last stage, which of course is compensation. If your case is settled, that's our favorite thing, is to be able to give our clients a check. If for some reason we haven't got the adjuster to take your case seriously, then we will recommend going to trial. And if I could say something about the trial, once we file the lawsuit, it has to be filed within 2 years of the date of the incident. That protects it against the statute of limitations. After that, the case could go on way longer than 2, 3, 4 years even. But as long as it's filed within 2 years, we don't have to worry about statute of limitations anymore. I know that most of the time, our claims don't have to go to trial because we've done such a good job detailing everything that they're going to have to deal with if this case were to go to a jury. But at the same time, we want our clients to know, don't worry about statute of limitations or anything like that. We monitor that very carefully and we would never miss a statute of limitation. So again, I hope this process is better understood. We hope this video has helped somehow in some small way. Obviously, if you have any other questions, please email or give us a call. We'd be happy to try to answer them for you. And then also see the other videos that we have available on our website, personalinjury.com, that answer a lot of other questions that many of our clients have. Again, thank you for trusting Hudson Law Firm with your injury claim, and thank you for letting us put personal back into personal injury law.